Yes, if you look on the account, your account details
Yeah,
there,
that, yeah.
it will say David, Sovereign Paralegals, are able to speak about
That's
this
right.
case. The clients received a communication from yourselves with a reduction in the offer from £160 to £79.
That's correct.
Yes, and this was dated the 6th of March, was it? I think you've sent this out, yeah. It was signed by Jennifer Jordan. She's the collections manager. Is that that's the case? Yeah.
It is, yeah.
Okay. Well, if I may just take some moment of your time then to explain, we offered. What's happened is, vehicle control services have gone out in a van and taken the registration of this this person's van, this man's van. So this is the owner that you've written to, Andrew. Okay, and he is running a business, and he had a driver operating that vehicle at the time. So when the vehicle control services patrol officers taken the initial location and time and whereabouts of the vehicle when it was in Barnsley, allegedly performing an infraction under Management Act, the Road Traffic Management Act, the gentleman was lost at the time, looking for directions. The engine was running, he was still in his vehicle. Vehicle control services have been round and obviously taken the photographic evidence and sent this to the owner. The owner has written into vehicle control services offering to give the name of the driver at the time. He's made a conditional acceptance offer, as I've advised him to do, and said he will provide the name of the driver for a small administration fee. Vehicle control services have written back to the van owner, the registered keeper and the owner, and said they refused the offer of contract and they still require the name of the driver. And I have intervened and rang them up and said that there is no lawful legal obligation for the owner and the keeper to hand over the name of the driver. He's running a business, and for him to take time out and administer this account, your account,
Yeah.
well, not your account, but Vehicle Control Services account, he can't be requested a £10 administration fee for his time spent relating, sorting these matters out. So that was rejected. I rang up Vehicle Control Services, the calls recorded and logged, and Elaine that I spoke to was told that they have rejected the offer, and legally, because I'm legally trained, they have created estoppel. They have ignored the facts and the offer to hand over the information, which is a legal requirement, not lawful, and there is no law saying that he must provide it. So I've advised him to advise of the £10 charge for doing so. The letter my client has got says they refuse the contract offer and they still require the name of the driver, or they're going to proceed to collections. So yes, Elaine was very helpful with me, and I rang her up and I explained this, and that now there is no legal way to go forward because it would constitute harassment and trespass.
Right, so,
yeah.
So on that basis, David, is Andrew going to supply the name of the person who was driving at the time?
Say that again, my love.
Is Andrew going to supply the name and address of the person who was driving that vehicle at the time?
There's no law that says he must oblige and do so. He will supply it for a £10 administration fee, of which has been declined. So he's offered, and the companies have got first-hand knowledge that he's willing to offer. He's running a business. He requires a £10 administration fee. That's been declined. So unfortunately, this is called acquiescence, ignorance to the facts now, and first-hand knowledge has been provided. So this then creates permanent estoppel, which means it's a game of it's stuck. We've got checkmate because you guys are still going to try and chase collection, and now I just wanted to ring up and inform you that Jennifer Jordan will be the one who's responsible for this, and I would need to speak to her relating to these matters because
They don't take calls on the floor.
What would I need to do? Would I need to write in then and say conditional acceptance? Because I've only ever telephoned your company because I've asked for a contract. I said that I don't work for free, and I've got a friend, a client in trouble legally. I've offered to help him out. He's offered to sort this out. This matter should have been dealt with regards to paying the £10 administration charge, much like the DVLA requests a small fee from the system when the control services want to, or the government want to find out the registered keeper. They put in a request and it drops off £2.50, which is a normal commercial transaction. So I need to let you guys know that we've also given a verbal cease and desist of a telephone call on this account. If you look on the records, I rang up and spoke to one of your operators and said that we are not willing to accept this claim because no contract has been applied. We've done everything legally and lawfully as well. We've complied with all the requests made, and obviously we're at a stalemate. So you've sent the offer for consideration out before legal proceedings. So I wanted to write in a letter. It's called a notice of default and an opportunity to cure. So this lady who's put her name, Jennifer Jordan, I'm the collections manager. I will use her name for the contact then, because she's ultimately given her public commercial liability as the collections manager will be the person that we claim against to counterclaim, as we've offered all the information and the contracts haven't been accepted via us and via vehicle control services. You guys are still enforcing the collection even though a verbal cease and desist has been given. And so I need to bring this down to it needs to come to a close now, because this letter will be rejected, this offer for £79, I needed to now put this finalise it into writing. And I've also let you guys know and written in that I've got a fee schedule, and you've said you don't want to contract with me, so by contacting me you kind of have contracted, because you've written back to me. So I thought a quick telephone call, can this be rectified over the phone, or do you require me to send in written notification of the objection?
Well, if you can, like I said, if you can send in written notification, David, but the balance is still payable at £79.99.
Yes, and I've since contacted my client and I said, look, you have the option to pay, not that you have been deemed guilty by any means of the law. You are not guilty. You have not been proven guilty under the bills of, under the various acts that we've got. I won't go through them all now with you, but I've been through them. We are not, we are not guilty until somebody has proven us guilty. So all fines and forfeits are void unless brought before a court of law and a judge. So you're applying fines and forfeits. I need to let you guys know what's happening here and the reason for rejection, and let you guys know that the verbal cease and desist has been ignored, and you're in waters of going to court now, and we're prepared to go to court and justify all these actions with you, and you'll find that it's illegal to proceed, but that's the manager's call, not mine, obviously.
Yeah, well, we wouldn't pay to court. It would be our client, which would be vehicle control services.
Yeah, exactly. And I just mentioned beforehand that we put the offer in for the name and the fee. That was rejected, so that creates the legal checkmate now, permanent estoppel. And my client, I've asked him if he would like to pay, and this situation will go away. He says I'm not guilty. I've offered to sort out the name of the driver, and they've rejected that. He said, so I've then advised him that if we go to court and a mistake is made or something isn't done correctly, he may be deemed liable. Some freak chance of nature that somehow he gets deemed liable. I said the worst case scenario, you may end up with costs of 400 plus for all this. And he says, I don't want to pay it because I'm not the one that should be paying it. The driver should be, and that's the law. So yeah, I will be having to send in some written notification. If you could make a note that the contact has been made by the client's representative, administrator for this account, and I will send you in communication with regards to this, that the offer that you've sent, the consideration offer notice, is going to be rejected on the grounds of it's illegal and unlawful for you to proceed at this point. And once the manager knows, then it's the responsibility and liability will lie on Jennifer, and she can get back in touch and see if she wants to sort this out. Or there's only two things you can do: either drop it legally and discharge it, or pay the £10 fee and get the name of the driver, which is what you should do in accordance with the legal and the lawful system we have. So is that, I didn't know if we could rectify this over the phone, or you'd want written communication sending in.
If you want to send that written confirmation in, but like I said, with it being with ourselves, the balance is still payable.
All right then, so that's fine. That's normally the case. I'd have to send it in registered post. I'll get it signed for. So I'm going to address it to this lady who's put her name on the bottom of the letter. Then the manager. You put a note on the account, please, and the letter will be with you. I'll draft that up this afternoon. It'll be with you in a couple of days. It's got an email contact and a telephone contact for myself. You may not contact the client because he doesn't consent, he doesn't contract. All communications through myself as per the instructions on the letter, and we'll see if this can be resolved one last time with Jennifer or the court case. Then we'll see what you want to do.
Okay.
All right then. May I take your name as a reference because I forgot?
Yeah, of course you can. You're speaking to Kate.
All right, Kate. Thank you very much for your help, Kate.
No problem.
All right. Thank you. See you later.
Thank you.
All right. Goodbye. Bye bye. So there we have it. It was issued December 2016, the 5th of December. It's now the 30th of May. If they had any legal authority to chase this up, they would have done so by now. Like I said just then, he's not unwilling to give the name of the driver. There is no law to say he's legally or lawfully obliged to give the name of the driver. Pardon me. He doesn't consent. He's not guilty. He's not been deemed guilty. As I said, all fines and forfeits are void under the Bill of Rights Act. You can also use these promissory notes to pay these fines, I do believe, as well. I've not met anybody that successfully used a promissory note, either endorsement of some kind maybe, but I think a promissory note could be used to pay these. I don't waste my time writing letters to these companies. As you've noticed, I've made a video catalogue of this case. All but one video, I think, is up on the Indigo Child channel. So, see what you think, guys. And we obviously are onto something, because if we wasn't, and we wasn't acting lawfully and legally, then they would have been round, clamped the vehicle, removed the vehicle, gone straight to court within a smaller amount of time. So, you do make the conditional acceptance offer, and you do agree to deal with this case, and you put the account into dispute straight away at the first available opportunity. Once the account is in dispute, then you deal with it with the conditional acceptance offer. Now, anybody that's invoked Article 61 and Magna Carta, you've also got lawful excuse on top of this legal remedy system to distress the regime and commit civil disobedience. Now, that's your belief. You do what you want to do. People ask me, should I do this, should I do that? I don't know what you should do. I'm doing what I think I should do, and what is in accordance with my beliefs and my religious system, my ethics, my conduct, my morals, my belief system. So I act in accordance with the governance of the Creator and common and natural law. Then, if I choose to, such as when I may become employed, I will then, as an employee, be liable to perform under the Health and Safety Act, the Data Protection Act, things like that, and I'll be committing commerce using my instrumentation, all caps name. So I am the flesh and blood man at my employment, place of commerce, self-employed, whatever, and I'm using registration at present in the form of PAYE, tax and employment records. They're recorded as my fiction, my straw man, my all caps, but I don't ever agree to be that name. And when I signed my contract with my present employer, I didn't sign without liability, I didn't indemnify myself, and I didn't sign under duress, because I knew not the information hadn't come to hand then, hadn't come to light. So now it has. I should really approach my present employer and say I'd like to amend my contract and sign it, so I've protected myself. But you see, you get the idea. Each situation is based on its merits, but there is a basic rule and principle of law of which you need to follow. Once you understand that and adhere to that, you can do that. You don't need to invoke Article 61, that's a personal preference, but you do need to act as your circumstances dictate. This is not lawful advice, this is just a study of different ways commerce and interaction and acceptance and payment can be offered as per the statutory guidelines, regulations, codes of commerce as a body, flesh, man, I, man, have the right to trade, levy, barter, as I see fit, without being licensed or regulated by another man, another corporation. A corporation can't make a contract with a man because it's a soulless, fictitious 2D entity. It only exists on paper. Yes, there is no Mr. Legal and General, but there is a corporate emblem, there is a registered number, there is shareholders, what am I on about? There are shareholders, and the HMRC have got it registered as a business, but it isn't a living entity, so it cannot perform or make a contract. It can make an agreement. So these corporations trying to enforce contracts via tacit, tort and adhesion, look at those words and look at the definitions of what they are, cannot be applied, but they can be if they use their presumptions of law and you can't show any intent and you ignore everything. They can try, and try they do, because even with the way that we use and the words we use and not contracting and the conditional acceptance, it's still bloody hard. But each to their own. Again, if you want to ignore it all and ignore it, and you think no contact and no contract is best, then you do that. If you think that getting in touch, and yeah, I agree, the system is corrupt and we are fueling the system, we are sending them communications, we are buying stamps and sending it recorded post, we are incurring expense to ourselves to just clear our name, and once we've cleared our name and got the case dropped, the charges discharged, we will be left out of pocket financially. So either way, the system wins a little bit, but they've offered the £70 fee because they've got to put within there something for consideration. Now this is the consideration, the contract part. They're making out that they're trying to barter and operate in accordance with governing guidelines for their business and commerce, but they aren't operating in accordance with those guidelines, and they're monitored by various regulatory bodies. They're appearing to, and I suppose they rely on the fear stage at this point, because if you look, you've got 170 quid owed, now you can pay 79. If you don't pay this, you've got to go to court. Well, the client's been advised of that. He's also been advised that it may be more than 79 quid if I make a mistake, or for some reason it gets upheld, then the cost will be substantially more than 170. So I've given the option now to bail out. And he turned around and said no, he doesn't believe he's guilty, hasn't legally done anything wrong, and so on principle is going to stick to, I've offered the name, there's no lawful legal requirement to do their job for them, I'm not guilty, I haven't been deemed guilty, yes, some of the particulars are correct, but they need the name of the driver, so that's it. If you want to go and give the name of the driver freely, then that's up to you, but they rely on fear and intimidation. Research it, there's no obligation to give it. It's the corporation have set up and gone out in a van with cameras on it and started driving around and sending people bills. Now think about it, who's governing them? Who's stopping you from going out and me from going out and putting up a van with cameras on and some stickers on it and just taking pictures of everybody? It might even be a little granny dropping off, a son dropping off his grandma outside the shops on double yellers, because she can't walk, she's just had a hip operation, and he's there for 2 minutes, and he puts hazards on, opens up his car, gets little old lady out, his grandma, takes her to the shop, gets back in the meantime I've driven past, got my camera on, seen him on double yellers, guilty. It's not how this country works. Even if you believe that we should pay these and that we should be adhering to the alleged authority and jurisdiction of the corporations that are making these demands and threats and trespasses upon our person's rights, and you've got to claim a right in this country. You've got birthrights, you've got inherent God-given creator rights, and you know that, and if you want to sacrifice and give them up and submit them, then you can do so. And if you want to appeal to these people, then you need to consider why you are appealing, because to appeal is to be deemed guilty. It's been a long road, this, learning all this stuff out, and they will change the guidelines and legislation and legal statutory regulations, because we're getting on to winners and we're slowing it down, and we are getting wins and we're getting them dropping cases. So to everybody that's been taking part in all these videos and that's been making notes, that's been researching, that's been trying it out, including to this client for having the guts to say, I'll still carry on, even though I can bail out for 70 quid, 79 quid, let's do it. So I've happened to save someone else in the family a bit of money with the council. The first case we took on, the council had put a claim in, and they didn't provide the legal and the lawful process. They didn't follow it, and the rule of law wasn't followed. They made a claim, they didn't have any evidence to back it up. We asked for the evidence to back up the claim. When they made the claim, they didn't have one, so they come out and did a statement of truth on an affidavit with the client's family member. Once that was done, nothing's been heard since. So the digital university of sovereign solicitors is growing rapidly. We're having successes. We don't know it all. We don't give legal advice. We're not registered or licensed. We don't use legalese. We are not free men. We are Anglican womb men, men of the water, and we are asserting ourselves in accordance with legislation and divinity and the guidelines of the Creator, the natural law, the common law. We are peaceful and loving. We don't cause any violence or disruption anywhere. We are aware of our obligations and statuses. We are aware that we are body and flesh. We are aware that there's a secret organisation running around committing acts of mass treason and just unlawful conduct, tyranny in every way, shape and form. So think carefully before you use your surname. Think carefully before you use your date of birth. Think carefully before you sign any contract. Think about what you're doing, why you're doing it, how you can protect yourself, who you are, what capacity, what you're liable for, everything. So another video update will come after this when they've got the letter and I get the reply from the collections manager. I can't see whether it's a wet ink signature from the collections manager, Jennifer, Jordan. Where's my camera? It's just a screenshot that someone sent me. So we have got a name. It's printed underneath. It looks like it's a computer sketch etch on that font. So it's exactly the same colour as the text, the signature you see. So that leads me to believe that if this is a real handwritten letter, printed letter, then hand signed, it would be a different colour there on the photo. But we will see. No contract, no consent. Peace and love, sovereigns. Ciao.